Legal and Privacy Brief for May 7, 2026. NIDS imposed a $2.25 million penalty on Delta Dental for MOVEit breach failures, including late notification and inadequate data retention policies. House Republicans released the Secure Data Act, which would preempt state privacy laws while offering weaker consumer protections than most existing state frameworks. Critical Palo Alto Network's firewall vulnerability, CVE 2026-0300. CVSS, the Common Vulnerability Scoring System, 9.3, is under active exploitation, with CISA, the Cybersecurity and Infrastructure Security Agency, ordering federal agencies to patch by Saturday. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief. May 7, 2026. Next section, Enforcement Actions. NIDS Delta Dental $2.25 M penalty, MOVEit breach. New York Department of Financial Services issued a $2.25 million civil monetary penalty against Delta Dental Insurance Company and Delta Dental of New York on April 29, 2026, for violations of Part 500 cybersecurity regulation. The action stems from the June 2023 MOVEit transfer, zero-day breach. NIDS charged Delta Dental with 4 violations under Part 500. Failure to maintain policies for secure disposal of non-public information no longer necessary for business operations, Section 500. 13. Failure to implement adequate written incident response policies, Section 500. 3N. Failure to establish incident response plans addressing regulatory reporting obligations, Section 500. 16b6, and failure to provide timely notice of a cybersecurity event, Section 500. 17a. Delta Dental identified a malicious web shell on June 1, 2023, confirmed data exfiltration by July 6, 2023, but did not notify NIDS until December 15, 2023, more than 5 months after confirming the breach. Approximately 60,000 files containing social security numbers, driver's license numbers, financial account information, and health data were exfiltrated. Delta Dental had disabled MOVEit's default 30-day retention settings, keeping files on servers longer than necessary without written policies governing retention changes. Compliance action. Review data retention policies for all file transfer systems. Ensure non-public information is deleted when no longer necessary for business operations. Notify financial regulators immediately when unauthorized access is detected, even before exfiltration is confirmed. Update incident response plans to include explicit regulatory notification procedures and timelines under Part 500 requirements. Sources: Debevoise Data Blog. Next section, Litigation Updates. Blue Cross Blue Shield $2.67 B, antitrust settlement payments. Begin. Blue Cross Blue Shield will begin distributing payments from a $2.67 billion class action settlement, resolving claims the health insurance provider engaged in anti-competitive practices. The settlement addresses allegations that BCBS insurers restricted competition through market allocation agreements and territorial restrictions. Source: Top Class Actions. Oglethorpe $350 K data breach settlement. Oglethorpe agreed to a $350,000 class action settlement, resolving claims that a 2025 data breach compromised sensitive consumer information. The settlement provides compensation to affected class members whose personal data was exposed in the incident. Source: Top Class Actions. Sportsman's Warehouse Pennsylvania Privacy Settlement. Sportsman's Warehouse agreed to a class action settlement, resolving claims it violated Pennsylvania data privacy laws by disclosing firearm purchase information without consumer consent. The settlement addresses allegations that the retailer improperly shared transaction data with third parties in violation of state privacy protections. Source: Top Class Actions. Equity Residential $56 M Real Page Rent Price Fixing Settlement. Equity Residential agreed to pay $56 million to resolve claims it participated in a rent price fixing scheme using RealPage's revenue management software. The settlement addresses allegations that landlords coordinated pricing through algorithmic software, violating antitrust laws by reducing competition in rental markets. Source: Top Class Actions. Supreme Court denies Apple stay in Epic Games contempt case. Justice Elena Kagan denied Apple's emergency request to pause a civil contempt order entered against the company in its ongoing dispute with Epic Games. The contempt finding stems from Apple's alleged violations of an earlier order prohibiting the company from blocking developers from encouraging customers to purchase games and products outside the App Store. The Ninth Circuit found Apple in contempt for implementing measures that made it more difficult for developers to direct customers to alternative payment systems. and for imposing large commissions on purchases made through third-party systems after users clicked links in the App Store. Apple sought Supreme Court intervention before litigating its commission rate under the contempt finding. Kagan denied the stay without referring it to the full court, indicating it was not a close call. Sources: Scadu S. blog. Matt Taibbi defamation, suit dismissed. Judge George B. Daniels dismissed journalist Matt Taibbi's defamation lawsuit against author Ian Higgins and bold type books over Higgins' book, Owned: How Tech Billionaires on the Right Bought the Loudest Voices on the Left. Taibbi sued, claiming the book's title and content falsely stated he was owned and bought by billionaires. The court ruled that the book's cover, jacket, and challenge statements were metaphorical, non-actionable opinion protected by the First Amendment. The decision explains that owned and bought are susceptible to both literal and metaphorical meanings depending on context, and that reasonable readers would interpret these terms metaphorically when applied to media figures and their relationships with financial backers. The dismissal reinforces that critique and commentary about journalists' relationships with wealthy supporters constitute protected opinion, not defamatory factual claims. Source: TechDirt. Next section: Regulatory Guidance. CISA, the Cybersecurity and Infrastructure Security Agency, Critical Infrastructure Isolation Initiative. CI Fortify, Cybersecurity and Infrastructure Security Agency, unveiled CI Fortify, a new initiative urging critical infrastructure organizations to prepare for technology and telecommunications outages caused by cyberattacks. The guidance recommends organizations proactively disconnect from third-party dependencies and develop operational plans for functioning without reliable telecommunications and internet during crisis or conflict. CI Fortify emphasizes network segmentation, isolation of operational technology systems, and rapid restoration capabilities while disconnected. CIS Acting Director Nick Anderson stated the agency will conduct targeted assessments of critical infrastructure organizations, though specific numbers and locations were not disclosed. The initiative addresses nation-state hacking campaigns, including China's Volt Typhoon, where threat actors prepositioned on U.S. critical infrastructure to enable destructive cyber action during potential kinetic military conflict. Compliance action: develop detailed emergency operation plans for functioning during telecommunications outages. Segment and isolate operational technology systems from other network components. Identify and document third-party dependencies that could be disconnected during crisis. Test restoration procedures for compromised systems while isolated from internet connectivity. Source: The Record. Palo Alto Network's critical firewall vulnerability, CVE 2026-0300. Palo Alto Networks disclosed CVE 2026-0300, a critical vulnerability, CVSS, the Common Vulnerability Scoring System, 9.3, affecting PANOS software and PS series and VM series firewalls with specific configurations. The vulnerability is under active exploitation targeting authentication portals exposed to untrusted IP addresses or the public internet. CIS a confirmed exploitation and ordered all U.S. federal agencies to apply Palo Alto's mitigations by May 10, 2026. Patch will be released over the next 2 weeks, with Rapid 7 estimating availability for many versions by May 13. Customers following security best practices by restricting sensitive portals to trusted internal networks face greatly reduced risk. Multiple cybersecurity firms reported exploitation following release of exploit code on Tuesday evening. Compliance action: immediately restrict Palo Alto firewall authentication portals to trusted internal networks if not already configured. Review which firewall interfaces are exposed to the public internet or untrusted networks. Apply Palo Alto's published mitigations immediately. Monitor for patch release expected May 13 and apply within 48 hours of availability. Review logs for unauthorized authentication attempts since early May. Source: The Record. FCC laboratory testing ban, China-based facilities. Trump administration, FCC announced plans to ban electronic device testing at laboratories with offices in China for products sold in the United States. Approximately 75% of U.S. bound electronics are currently tested in Chinese facilities, with 27 affected facilities operated as Chinese subsidiaries of major Western testing firms including Intertek, SGS, TUV Rainland, and Bureau Veritas. Basic FCC certification testing costs $400 to $1,300 at Chinese labs compared to $3,000 to $4,000 at U.S. equivalents. The policy would require companies to redirect testing to facilities in the U.S., Europe, or Taiwan, significantly increasing compliance costs that will likely be passed to consumers. The ban applies to companies with testing offices in China regardless of ownership, affecting U.S. and European testing firms operating Chinese subsidiaries. Compliance action. Identify which products require FCC certification testing and which laboratories currently perform that testing. If using Chinese-based labs or subsidiaries of Western firms operating in China, establish relationships with U.S., European, or Taiwan testing facilities. Budget for 2 times to 3 times increase in testing costs for products requiring FCC certification. Monitor FCC rulemaking for implementation timeline and final scope. Source: TechDirt. Next section, privacy developments. Federal Secure Data Act proposed, House Republicans. House Energy and Commerce Committee Republicans released the Secure Data Act draft without bipartisan support. The bill would preempt state consumer privacy laws under Section 15, eliminating the 21 state privacy laws passed in recent years, all 50 state data breach notification laws, and state laws governing specific categories of sensitive data, such as biometric and location information. The bill provides standard data rights, access, correction, deletion, limited portability, and requires consumer consent before processing sensitive data or using personal data for previously undisclosed purposes. Consumers can opt out of targeted third-party advertising, data sales, and certain profiling, but companies may continue these practices unless consumers opt out. The bill requires data brokers earning at least 50% of profits from data sales to register in an FTC, the Federal Trade Commission, public database. The bill does not include private right of action for consumers, limiting enforcement to FTC and state attorneys general. Critics including EFF and Epic argue the bill reinforces failed notice and choice models, permits massive data overcollection to continue, and would eliminate stronger state protections, including California's data broker deletion tool and automatic opt-out signal requirements. Compliance action. Monitor Secure Data Act progress through House Energy and Commerce Committee. If enacted, the bill would eliminate state-specific compliance requirements but establish weaker federal baseline. Companies currently subject to California, Virginia, Colorado, or Connecticut privacy laws should not reduce existing compliance programs until federal preemption takes effect. Prepare for potential FTC data broker registration if company earns 50% or more revenue from personal data sales. Sources: EFF Deep Links Epic News. HUD proposed AI tool using Sensitive Data Department of Housing and Urban Development published a notice of intent to modify its system of records to collect new categories of personally identifiable information and introduce AI features that would generate draft case summaries and suggested email responses using case information and internal knowledge bases. Epic and Center for Democracy and Technology submitted comments opposing the changes, arguing HUD's notice lacks details about system accuracy, fitness, safety, security protocols, and accountability mechanisms. The notice suggests these AI practices are already operational prior to publication, which Epic and CDT argue violates the Privacy Act. The organizations urged HUD to roll back the changes and conduct proper Privacy Act compliance before implementing AI systems processing sensitive housing assistance data. Compliance action. If your organization works with HUD programs or submits case information to HUD systems, inquire about AI processing of submitted data and whether you can opt out. Review contracts and data sharing agreements with HUD for AI processing disclosures. Monitor HUD's final system of records notice for details on AI implementation and data retention. Source: Epic News. California AI chatbot mental health liability. Law California passed legislation requiring AI chatbot providers to implement protocols preventing production of suicidal ideation if engaging in mental health conversations, with liability for conversations linked to harm. The law will likely result in chatbots responding to emotional distress by displaying 988 crisis line numbers or terminating conversations. New York is considering legislation that would ban chatbots from discussions suited for licensed professionals. Critics, including Professor Jess Mears, argue the liability regime will make chatbots less safe by incentivizing providers to cut off mental health conversations entirely rather than provide continued support. Research shows over 1 million people per week use general-purpose chatbots for mental health support, with many reporting positive outcomes. A replica study found 30 users credited the chatbot with helping them avoid suicide. The laws follow high-profile tragic cases, but may eliminate beneficial mental health support for larger populations not in crisis. Source: TechDirt. Illinois Chatbot Provider Liability Framework, HB 5044. Illinois House Bill 5044 would establish chatbots as products for purposes of product liability law, allowing chatbot providers to be held strictly liable for harms their chatbots cause. Epic counsel Cara Williams testified in support of the bill on May 5, 2026, stating it represents an important step toward tech company accountability and justice for people harmed by dangerous products. The bill is based on the liability section of Epic People First Chatbot Bill and would create a clear liability framework for chatbot-related injuries. Source: Epic News. Next section, policy changes. Supreme Court Voting Rights Act decision, Louisiana v. Calais. Supreme Court finalized its decision in Louisiana v. Calais, striking down Louisiana's congressional map under the Voting Rights Act and requiring the state to draw a new map before the 2026 elections. The decision limits the use of race as a predominant factor in drawing election districts, even when necessary to comply with Section 2 of the Voting Rights Act. Justice Samuel Alito's majority opinion applies strict scrutiny to districts drawn to protect Black voters, holding that preventing discriminatory effects against voters of color is not a sufficiently compelling government interest to justify race-based districting. Justice Ketanji Brown Jackson dissented, joined by Justices Sonia Sotomayor and Alina Kagan. The decision will likely result in redistricting throughout the South that reduces majority-minority districts designed to protect Black voter representation, with expected decreases in people of color elected to Congress and state legislatures. The ruling follows decades of Supreme Court decisions limiting the Voting Rights Act, including City of Mobile v. Bolden, requiring proof of discriminatory purpose, Shaw v. Reno, applying strict scrutiny to race-based districting, and Shelby County v. Holder, striking down preclearance requirements. Sources: Scadu S blog, Scadu S blog. South Dakota Citizenship Proof, Voting Law. South Dakota enacted legislation requiring state residents to prove citizenship to participate in state and local elections, with non-citizens restricted to federal elections only. Governor Larry Roden signed the bill following claims of widespread non-citizen voting, though Director of Elections Rachel Solek testified only one of 273 identified non-citizens had ever cast a ballot in the 2016 general election, likely due to clerical error. The law creates confusion among county election officials about acceptable proof of citizenship. Hughes County requires physical driver's licenses showing both front and back, while other counties are adopting varying standards. Critics argue the law suppresses voter turnout by adding confusion and barriers to voter registration, particularly affecting mail-in voting. The legislation follows Supreme Court precedent in Louisiana v. Calais, permitting voting restrictions that do not explicitly state discriminatory intent. Source: TechDirt. Next section, compliance takeaways. Notify financial regulators immediately when detecting unauthorized access to systems. NID's $2.25 M Delta dental penalty demonstrates regulators expect notification when web shells or unauthorized access are detected, not when exfiltration is confirmed. Part 500 requires notification within 72 hours of determining a cybersecurity event has occurred. Unauthorized access constitutes a reportable event. Review and enforce data retention policies for file transfer systems. The Delta dental penalty highlighted violations of Part 500 Section 513 for failing to delete non-public information no longer necessary. Disable unlimited retention settings on file transfer platforms. Document business justifications for retention periods exceeding vendor defaults. Audit MoveIt, ShareFile, and similar systems for compliance. Restrict Palo Alto firewall authentication portals and apply CVE 2026-0300 mitigations immediately. CISA ordered federal agencies to patch by May 10. Private sector organizations face the same risk. Limit firewall management interfaces to internal trusted networks. Apply vendor mitigations now, patch when available, expected May 13. Prepare for Secure Data Act federal preemption of state privacy laws. If enacted, the bill would eliminate state-specific requirements but establish a weaker federal baseline. Do not reduce existing compliance programs until federal law takes effect. California's automatic opt-out signals, data broker deletion requirements, and private right of action would be eliminated. Monitor state AI liability frameworks for chatbots. California requires protocols preventing production of suicidal ideation. Illinois HB 5044 would establish strict product liability for chatbot harms. If your organization operates AI chatbots engaging users in mental health, counseling, or emotional support conversations, prepare for state-specific liability regimes and content moderation requirements. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.